My 935 6M flight credit vanished. Expedia told the Attorney General there was no record. On October 8, 2025, a small claims judge ordered them to pay me back, plus court costs. This is how a 4-year fight ended with a tiny, beautiful victory. If you've ever been burned by a travel company, hit subscribe and like. And if you've got a story of corporate stonewalling, tell it in the comments. You won't be alone after this. I still remember the day I first saw the credit in my Expedia account in 935.67. It was a number that represented more than money. It was the promise of a trip taken from me by a global pandemic and a small, digital voucher meant to make me whole. The booking was with British Airways, made through Expedia in 2021, canceled because of COVID-19. Expedia emailed the credit. The email had their logo, the number, the expiration date, September 30, 2025. Everything looked official. I breathed easier. But the first time I tried to actually use that credit, something weird happened. I'd found the exact same flight I'd had before. Same dates, same seat class, same airline. When I toggled use credit, the price didn't stay the same. It ballooned. It didn't creep up. It jumped like a trapdoor beneath me. 2, even 3 times the cash price. It was as if the credit carried a penalty that showed up only when I tried to spend it. I sat there staring at the screen, pulse thudding. The room suddenly too small, my jaw clenched. My hands hovered over the keyboard, wanting to scream at a corporation that didn't know me but seemed intent on taking my money. That was the first red flag. The second came 4 years later, in June 2025, when the credit simply disappeared. No warning. No, "We'll purge this soon" email. 1 minute it was in my account, the next, gone. I pulled up the original emails from Expedia, the voucher, the confirmation, the expiration date, and sent them to customer service. Their responses were a repeated script. "We have no record of a credit. We cannot locate your booking." Each reply felt like yanking another tooth, irritating and completely unnecessary. People assume that large companies are organized, precise, that emails equal records, timestamps equal proof. They aren't always. Expedia's agents, when pressed, either claimed ignorance, fell back on glorious, sounding phrases like policy, or simply stopped responding. I could see it in the tiny details, the canned responses, the long pauses while agents checked, then the abrupt transfer to voicemail. One rep told me, flatly, "There's nothing here. You must have mistaken another account." My fingers hovered over the phone until anger turned into a cold, planning clarity. This wasn't a mistake. This was a wall being put between me and my money, so I started keeping an obsessive log. Screenshots, emails, dates. Time, stamped call logs. I saved every Expedia email with their own subject lines into a folder called Evidencie, like some digital talisman. I documented that whenever I tried to use the credit, the same itinerary's price spiked 2-3x versus paying cash. I wrote down agent names. I recorded the tone of voice, the exact phrase when they said, "We have no record." Documentation became my oxygen. When polite requests went nowhere, I escalated. I filed complaints with the Better Business Bureau, my state's Attorney General, the U.S. Department of Transportation, and the Federal Trade Commission. I filed them not because I was naive enough to think any one agency would snap their fingers and fix this, but because I wanted a paper trail, a legal breadcrumb path showing I had tried everything before resorting to court. That's when Expedia leveled up their stonewalling. They sent a statement to my Attorney General saying they had no record of the credit or the original booking. They lied. It's a brutal sentence to type, but it's true. When I pushed harder, after sending formal, pointed emails to the CEO, the Chief of Staff, and the Chief of Global Operations, my case was escalated to something they call the Global Traveler Resolutions Team. Suddenly the credit reappeared. But now they had a new play. The credit was allegedly covered under British Airways, book with confidence, policy, and could only be used if I spent new funds equal to the credit. In other words, spend 95.67 yourself to use the 9035.67 credit, a refund dressed as a trap. When I asked where this rule was written, Expedia offered 5 different versions of the policy over the course of a month. Each version changed the rules, like someone editing a script in real time. So I did what I do when a company starts spinning. I researched. I contacted a consumer advocacy organization. I contacted British Airways. Both confirmed independently that Expedia's shifting justifications were false. I emailed Expedia those confirmations. Their response, silence, or worse, they terminated calls, closed the case unilaterally, and ignored the emails. It's one thing to lose money. It's another to be lied to, stonewalled, and then erased. That's when I made a decision most people don't make, or don't have the patience to make. I sued. I filed a claim in small claims court. My filing wasn't poetic. Breach of contract, they issued a credit, then purged it. Omission of a material fact, they didn't warn me that the credit could be purged early. Unfair practices, price inflation when using credits, forcing me to spend new funds, and deception, misrepresentation, lying to the AG and BBB. And because Expedia had refused to produce call recordings, claiming they were overwritten after 90 days. Despite my request being made less than 14 days after the calls. I added their deliberate concealment of evidence into the petition. There's a particular kind of focus that arrives when you prepare for court. You stop being reactive, you become methodical. I created 3 identical evidence binders, one for the judge, one for Expedia's counsel, and one for myself. Each binder had every email, every screenshot of the inflated fares, the consumer advocacy correspondence, the British Airways confirmation, my complaint filings, and a succinct, chronological timeline, the story compressed into a thread you could read in 10 minutes and understand exactly why this was not some petty 935 fight, but an assault on consumer trust. Expedia's legal team did what corporate counsel often does when their name is on the suit. They offered a refund. Through the Attorney General complaint process, they offered the full 935.67 once. I refused. Not because of stubbornness, but because that offer didn't account for court costs, and it didn't put anything on the record about their unlawful behavior. They tried again a month later, and then again 2 days before the hearing. Each offer came with an implication. We're doing you a favor? No. The correct phrasing is they were returning my money that they had no right to keep. The courtroom itself was an ordinary municipal small, claims room, linoleum floor, a judge with a stack of cases, and a table for corporate lawyers whose suits cost more than my yearly travel budget. Expedia's lawyer arrived, looked through the binder I'd provided to him, as if every email was a new surprise, and tried to bulldoze with a narrative. There are no laws entitling you to court costs, he said more than once, in a tone meant to unnerve. He implied my demand was aggressive, unreasonable. He tried to dance around liability, but the judge, who had my binder and the timeline laid out, asked pointed questions, read Expedia's own emails printed and highlighted, and watched the video evidence of the inflated fares. When the judge put the hammer down, it was quiet and definitive. Judgment entered in my favor for the full amount of the flight credit, to a 935.67, plus court costs, October 8, 2025. The date sits in my head the way some people remember wedding days or births. Relief hit first like a weight being lifted, then an odd, stubborn sort of joy. This wasn't just about me getting money back. It was a public acknowledgement that a large company could not erase a consumer's rights with clerical chicanery and scripted denials. I cried, quietly, in the courthouse hallway. Not out of triumphalism, but because the exhaustion of 4 years. The nights I stayed up organizing evidence, the dizzying, anger-driven search for answers, finally sloughed off. My hands trembled when I held the judge's written judgment. The money itself wasn't life-changing. The judgment, however, mattered. It was vindication and precedent, for me, and for anyone else who might consider taking the same step. If you're thinking, could I do that? You can. I am not a lawyer. Small claims is designed for people without lawyers. Here's the practical, battle-tested playbook I used, condensed. Save every email, take screenshots of every price comparison showing cash price versus credit price, log call times and agent names, and keep a running timeline. Names, dates, times matter. Submit complaints to the BBB, your state attorney general, the DEOT, and the FTC. This creates an official record and shows a judge you tried other remedies first. Send a demand letter to the company's executives. Copies to the CEO, chief of staff, and head of operations can trigger escalation. If they claim policy reasons, get those policy excerpts in writing. If they provide shifting stories, print each one and timestamp it. It's inexpensive, it's accessible, and corporations must legally respond. Prepare a simple, clean binder with copies for the judge, the defendant, and yourself. Speak calmly. Present the timeline, the emails, the screenshots. Let the judge read your organized documentation. The story will speak for itself. I decided to go to court not because I loved litigation, but because I wanted a public record that said you cannot treat customers like ghost accounts. Corporations build profit engines that sometimes rely on consumer inertia. They count on you giving up after a long hold time or a confusing email. Don't let them count on you. If this story helped you and you want more breakdowns like this, step-by-step court prep, what to include in a binder, sample demand letters, let me know in the comments and I'll make a follow-up. Also tell me, have you ever taken on a corporation? What happened? Hit like if you believe accountability matters. Subscribe for more real world revenge stories that are legal, strategic, and utterly satisfying. And share this with a friend who has a travel credit collecting digital dust. Justice in small claims isn't always dramatic. Often it's slow, methodical, and messy. But sometimes it's a judge's pen and at a date on a page that says you were right. And for me, that was everything.